Do you understand all of the rights and plea options I explained to everyone earlier?
Yes, Your Honor.
Do you have any questions regarding
No.
those? Okay. Did you receive a copy of the charge filed against you?
Yes, Your Honor.
You're charged with 1 count of assault. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand the maximum potential penalties you face if convicted?
Yes, Your Honor.
And how would you like to plead to this charge?
Not guilty.
The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
Probably.
Okay. Do you have any source of income?
Yes, I work currently.
Okay, in order to qualify for court-appointed counsel, you need to meet certain poverty guidelines.
Right. I don't feel that I'll meet those criteria.
Okay. Okay. So, do you anticipate retaining an attorney then to represent you?
Honestly, I was hoping to deal with this today and be done with it.
Yeah, so this is just your initial appearance hearing. Yeah, the prosecutor's not here for these cases, or these hearings, so we'll have to set it for another hearing, but you know, this is a serious offense. It's I always strongly advise people to have an attorney to advise and represent them in cases like this. So my only question is, are you planning on retaining an attorney then if you're not going to qualify for court?
More likely, I mean, I'm not going to go through it.
Okay, do you happen to know who you're going to retain yet? Okay. Okay. One of the things I explain to people is when they tell me they're going to retain an attorney, retain an attorney and show up to court with an attorney.
Right.
Don't show up, oh, I didn't have time to get an attorney or whatever. I mean, because then I get a little upset by that stuff. So yeah, okay. So I will indicate we'll be retaining an attorney. Okay. The law director has submitted a written bond recommendation asking that bond be set in the amount of $10,000 personal recognizance. The allegations are that on May 10th, 2025, the defendant assaulted Paul Schleich at the True North gas station, and asking that you be ordered to have no contact with Paul Schleich while this case is pending. Is there any reason you need to be in contact with Paul Schleich?
No, Your Honor, I have a question in that matter for you.
Go ahead. As long as it's procedural.
Oh, right.
Yeah.
This gentleman proceeds to drive past my house and threaten to shoot me. Do I have the right to press charges back against him for such said things?
Yeah, you need to call the police.
I've read a report about it that it happened. Sergeant Sullivan showed up at my house.
Yeah, ma'am, I'm not talking to you. Yeah, I know, but you're not being recognized right now because I don't even know who you are. So I'm engaging with the defendant, not with anyone else. Thank you. Okay, go ahead.
Sergeant Sullivan was called on the day after the incident, well, the day of the incident on Wednesday. Would have been like the 16th or whatever day that Wednesday was following that Saturday. He showed up and said he would speak to the gentleman and rectify the situation.
Okay. I find the defendant, Mr. Beeman, has no prior criminal history. Bond will be set in the amount of $5,000 personal recognizance. I'm ordering as condition of his bond, he have no contact with Paul Schleich while this case is pending. I will set this case for a pretrial conference in the near future. So what all of that means, Mr. Beeman, is you're being released on your own recognizance. You don't have to pay anything today. But you are going to sign documentation at the clerk's window, which is a bond. It's a promise. And you're going to promise the court that, one, you're going to show up at every court hearing, and two, that you're going to have no contact with Paul Schleich. I know. And if you violate any of those, if you fail to come to court, if you have contact, I could revoke your bond, I could issue a warrant for your arrest, and then I could, at that point, order you to pay the city of Conneaut $5,000 as a penalty. Do you understand that?
Yes, sir.
Okay, do you have any questions?
No, I don't think I do.
Okay, so you can go to the clerk's window and they give you a date and time for your next hearing.
Okay.
And then go as quickly as possible to find a lawyer to represent you.
Your Honor, can I ask you a question?
No, thank
Well,
you.
I
You're
don't
not,
think
ma'am,
Mr.
you're not a
Chavez-
party to this case. So,
I am because he trespassed in my house.
yeah, thank you. Ma'am, hold on, get in here. Ma'am, who are you talking about?
Him. When he
Who's him?
came to
Who's him?
serve.
My bailiff?
Yes.
When he served my summons,
I have it on
walked away from
camera.
the door.
When he came to serve him his paper, he walked. I was asleep upstairs in my house, and he walked through my front door. Him
No,
and
no.
the bald guy that was with him.
Okay, ma'am.
Which
So
seems
is that
to be
is that trespassing? Because he didn't have the right to walk in my front door.
Yeah, well, I'll address it with him outside of your presence, but the only thing I can say to you, ma'am, is he has a job to serve papers.
Not to walk into my
Yeah,
house.
get out of the courtroom.
Okay. I'll press charges
Court is now calling State of Ohio versus Thomas Wing, case number 25 CRB 135. Good morning. Mr. Wing, did you understand all of the rights and plea options I explained to you earlier?
Yes.
Do you have any questions regarding those?
No.
Okay. Did you receive a copy of the charge filed against you?
Yes.
You are charged with one count of obstructing official business. That is a second-degree misdemeanor. If convicted of this offense, you face a maximum 90 days in jail and a maximum fine of $750 plus court costs. Do you understand the maximum potential penalties you face if convicted of this offense? I'm sorry?
Yes.
Okay. And how would you like to plead to this charge?
Like to plead not guilty.
Okay. The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
I've contacted an attorney through court appointed. I see them at 1:30 today.
So you're going to retain your own attorney?
No, court appointed.
Okay. Who are you going to see?
At 1:30 today, I go to the office in Jefferson.
Okay. Which office? Do you know?
The court appointed lawyer.
Okay. I have an appointment. The judge appoints the attorney. You don't get to appoint your own attorney.
Well,
So you're going to Jefferson. Do you know where in Jefferson you're going?
Next to pizza. Domino's Pizza.
Okay. I'm going to ask you some questions regarding your finances. Do you have any source of income?
No, well, just Social Security,
How much do you receive in Social Security income?
$960 a month.
Is that your sole source of income?
Yes.
Okay, based on that, I do find that you preliminarily qualify for court-appointed counsel, and I will appoint the Public Defender's Office to represent you. You'll have to fill out what's called a financial disclosure form. Usually we have somebody from the Public Defender's Office here at court, but they're not here today. So the clerk will give you the financial disclosure form. You'll have to complete that, or you'll have to go to the Public Defender's Office to complete that to ensure that you do indeed fully qualify. But based on what you told me, I do find you qualify. The law director has submitted a written bond recommendation asking the bond be set in the amount of $5,000 personal recognizance. The allegations are that on May 12, 2025, the defendant obstructed the performance of sheriff's deputies by refusing to comply with their orders to exit a vehicle in Kingsville Township. Okay. The complaint has you listed at 322 Franklin Avenue in Ashtabula.
Yeah,
And how long have you lived there?
about 10 years.
I will accept the bond recommendation, $5,000 personal recognizance. I will set this case for a pretrial conference in the near future. So Mr. Wing, you're going to go to the clerk's window after you leave the courtroom. They're going to give you a date and time for your next hearing. And at that time, the public defender will be here to represent and advise you. You need to be at that hearing. If you fail to appear for that hearing, I could issue a warrant for your arrest. Do you understand that?
Yes, Your Honor.
All right, you
Sorry.
signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane and we were at the red light. And when we were driving through, I got in front of him and then he got into the turn in lane. And then he says he was going to turn, but I don't think he was because of the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
heading,
we collect-
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from
So
Ann Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right. Where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station?
not.
Did not. Would you dispute that the aggregate amount of damage that can include repair cost was in excess of $1,000?
For mine or for his?
Total.
So you obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it
You'll
was over
stipulate that
1,000.
the damage, total amount of damage to both vehicles was in excess of 1,000, including repair cost. You'll stipulate to
Yes.
that, counsel. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th. At 9 a.m.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, bond will continue. You'll stop down at probation on the way out. just to
Okay.
Check out. All right.
Okay, thank
Thank you,
you.
Your Honor.
Thank you. Court does call the case People versus Michael Klustra.
Ashley Lonnie for the people.
Morning, Anna Uwe Das with and on behalf of Mr. Klustra, standing to my right. Mike, please state your name for the judge.
Michael Klustra. All right.
We have an adjourned plea trial, had discussions with Ms. Landi. Make counsel approach, please.
Yes, briefly,
Thank you.
folks.
Today's the day.
I got a whole
I
lot
know.
of cases.
Very
All
good.
right, thank you. Court does call the case, People versus Gabriel Boyd.
Ashley Lonnie for the people.
Good morning, Judge. Rita Spargich on behalf of Ms. Gabrielle Boyd. Judge, I had a very lengthy conversation with my client last night. I am quite shocked she's not here this morning and very, very surprised. I'm hoping that she's okay. So I'm just asking if you could just pass it for a moment. I've been trying to get in touch with her, but this is quite shocking. She's been here every single time. So I hope that
So it was a good conversation?
yes, very
Oh,
good
okay, all
conversation.
right. I don't know, maybe you were yelling at her.
No, it was not anything bad. That's
No,
why I'm a little
okay.
bit, I'm a little bit worried about it. If you could just pass it.
I'll pass.
Thank you. I appreciate it.
Court does call the case, People versus Rebecca Dilworth.
Ashley Lonnie for the people.
On behalf of Ms. Dilworth, I'm not sure if she's logged into Zoom yet, Judge.
And Your Honor, I have prepared a nollie in this case. If she's not, I don't know if the court's received it yet.
I don't have Miss Dilworth.
With the case, Judge, we are asking that the court excuse her presence. We are expecting a dismissal from the people anyway.
You're moving to dismiss.
That's fine. Yeah, it works on its way. It should be here anytime now.
Okay. Thank you, Judge.
Case is dismissed. Thank you. Court does call the case of the People versus Natasha Olmos.
Ashley Lonnie for the people.
Kyle Burdell on behalf of Natasha Olmos, who's approaching the podium. And Ms. Olmos, please state your name for the record.
Hi, good morning, Natasha Olmos.
Thank you. What are we doing?
So, Your Honor, we are currently in plea negotiations. I believe we can come to a resolution soon. We are asking for an adjournment in this matter. I believe the court was giving June 4th or the 18th.
Yes.
I'd ask for the 18th. I'm not available on the 4th.
People picking their dates again. June 18th, 2025, 9 a.m. Bond continued.
And if we maybe heard us to bond.
Yes.
Thank
Go
you,
ahead.
Judge. So, Your Honor, Miss Olmos has been on a sober scram tether since the inception of this case. She's had no issues. There's been no positive tests, nothing with the tether. We are asking that.
Operating with an occupant less than 16.
Yes, Judge.
She'll remain on the tether, if that's what you're going to ask.
Thank you, Judge.
Thank you. Court does call the case of the People versus Arello Beavers.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Beavers, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
I don't have him there either.
Your Honor, I did speak to him.
Arello Beavers? We have no response.
Your Honor, I did speak to him and did anticipate that he would be here today. I don't have an explanation for his failure to appear. For the record, I'd request an adjournment.
Beavers? No, not here. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the cases of the People versus Byron Blair.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Blair, Your Honor, who I do not believe is present.
I have Cedric Blair.
Oh, Cedric Blair.
Hello, who are you? That's Cedric Blair. That's not Byron.
I believe so, Your Honor, based on his voice. So as to Mr. Byron Blair, Your Honor, he does not have a working phone number. He is usually a resident of the Delana Center. I did send him an email and I did not hear back. To that end, I do not have an explanation for his failure to appear, and for the record, would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege on it. Thank you. Court does call the case of the People versus Cedric Blair.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cedric Blair, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Cedric Blair. All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading no contest to the added count of retail fraud in the third degree, and in exchange, count one will be dismissed.
That's correct, Your Honor. That is contrary to MCL 7503560 as in dog 4, 93 misdemeanor, $500 fine or trouble amount.
Sir, please raise your right hand. You'll need to unmute now, Mr. Blair.
I was trying to.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name again for the record.
Cedric Blair.
All right, you can put your hand down. Mr. Blair, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
If I may, Your Honor.
Or plead no contest, I'm sorry.
Thank you. That's what I was just about to say. Excuse me, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand about it is it means that the court is going to treat you the same as though you had pled guilty for the purposes of sentencing. You understand that?
Yes.
Basis of no contest plea.
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
That's correct.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you'll be giving up your trial rights, which are described in paragraph 5, as well as all of the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? That was a question, sir. Are you on probation or parole? Did he freeze?
Yes, he did. He's here though.
There we go.
He's
There we
back.
go.
Okay. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-16486. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue. I don't have probation. I do. All right. Bond will continue. Sir, wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process.
Excuse me. Hello?
Yes.
You said I'm just automatically on probation? I'm just curious.
I didn't say that.
Oh, okay. That's why I was asking, Your Honor. No disrespect.
All right, but my probation department will interview you and will make a determination. So you need to wait on the line. You'll go into a breakout room with my probation department so we can start the process.
Okay.
Thank you.
Thank you, Mr. Blair.
Court calls the
Thank
case,
you.
People versus Candace Brooks.
Requesting to practice pursuant to
You
Michigan.
got to come closer to the microphone. This is your first time doing this, right?
Yes, Your Honor.
Okay, go ahead.
Okay.
Take your best shot.
Your Honor, Christina Barrick-Darian requesting permission to practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Londy.
I won't embarrass you by going through the series of questions. I did that the other day. I know where you're from, where you are, right? You're at Wayne State, right?
Yes.
Okay. Good school. You like Wednesday? No, you do? Okay, we'll let her practice. Permission to practice is granted.
Your Honor, Christina Berger for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Ms. Brooks, can you unmute and state your name for the record, please?
Candace Brooks.
Okay.
We are requesting an adjournment. Just want a little bit more time to talk to the people about a potential offer.
Hearing no objection, I'll adjourn this matter June 4th, 2025, 9 a.m. Thank you. Court calls the case of the people versus Jason Brooks.
The people. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Oh, thanks. Please state your name.
Jason Brooks.
Thank you, sir.
Your Honor, I am requesting an adjournment. I was unable to speak with Mr. Brooks prior to today. I'll get updated contact information, just make sure we have the right number for him before he leaves the building.
All right, June 4th, 2025, 9 a.m.
Thank you.
Thank you, Mr. Brooks. Court calls the case of the people versus Zachary Burlett.
Ask the line of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who should be present
Of
via
last
Zoom.
year.
Sir, can you please unmute and state your name for the court?
Zachary Burlett.
There he is. Okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did you say?
Just getting my notes pulled up there.
Oh, okay.
One moment to draw my screens. That's correct, Your Honor. We are going to be dismissing this case.
Certainly no objection to that.
Case is dismissed. All right. Thank you, Mr. Burlett. Take care.
Have a good day.
Thank you, Mr. Burlett.
Court does call the case of the people versus Justin Goltowski.
Ashley for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Goltowski, who I do not believe is present, Your Honor.
He's in.
Oh, he's in Zoom. Perfect. So my message got to him.
State your name, sir.
Justin Goltowski.
Thank you.
Thank you, Your Honor.
You're probably going to need an adjournment.
I am respectfully requesting an adjournment. I was able to speak to, I believe it was his roommate yesterday, so I'm glad the message got passed along. That is excellent news. But I do need to talk to Mr. Goltowski himself regarding his case, so I'd ask for an
June
adjournment.
4th, 2025, 9 a.m. All right. Thank you, sir.
I got a phone number for you. It's for my attorney, if you don't mind.
What'd you say?
I have a new phone number for my attorney, if you don't
Okay,
mind.
I don't want you broadcasting it that way.
Okay.
So
One at a time, and if she's not able to get everything accomplished, the court reporter, because two people are speaking over each other, the Court of Criminal Appeals has said somebody's going to get in trouble. It's not going to be me. It's going to be you. Let's don't speak over each other. And when I speak, you've got to stop because I've got to figure this out here. Okay. So this isn't a trial, but it is an odd thing that it's taken so long, especially since you've been living at the same address. That's weird. I mean, they know where it's not. You've flown the coop and moved off to another country or something. This is weird, but sometimes this happens. You got to deal with it now. Are you employed somewhere?
That's what I wanted to address. I worked for the county for 2 years and I got 2 background checks. One for the company that I work for and one for the sheriff's office, and they both came back clean. So
yeah, which goes to show you a warrant is going to be clear. When there's a warrant issued after an indictment, it's in the records, and maybe the people who were doing the background checks didn't do a good job, because that's odd. This should have been discovered a long time ago. But warrants are issued after indictments. They're done routinely. And the fact that people did background checks and didn't discover you is something else. There's something dropped, the ball was dropped somewhere, but nonetheless, those people who may have dropped the ball aren't charged with a crime, you are. So it's your situation you've got to work with. So where are you working now?
I'm no longer employed because of the.
Okay, you don't have an income?
No, sir.
You need to fill out one of those indigent forms, okay? And then if the court approves, then an attorney will be appointed to represent you. This is just crazy. I don't know how many mistakes can be made in one situation like this. Finally, I've got Robert Shrout. Okay. For what?
Allegation.
How long is this going to take? Is it long or succinct?
10 minutes.
Go ahead.
Yeah.
On Aron Atia.
Sounds like they may want to do a plea. The one you're just calling.
This one?
Yeah. It was his attorney.
Mr.
He's out of town.
It's the same last name.
They're not related. I've asked before.
What are the odds of that?
It's a popular name.
It is. I've never heard of it. I've heard of Smith and Jones. No, that's the others. Anything can happen. What are we going to do on Mr. Atia?
I guess, sir, essentially, I went over the offer. We are in agreement. We are in agreement, Judge.
You want to dispose of it today?
Yes, sir.
Okay.
Yes,
Can you fix it up? And
Absolutely. I was just.
thank you, sir.
Yes,
I see both of y'all had the same last name.
Yes, sir.
What
Not
are the odds?
related, though. Not related.
Sir?
Not related though.
Not related
Yes,
though?
sir.
The background is what?
We're both Pakistani. Both
Oh.
Pakistani. Yes, sir.
Oh, Kia Ale. Hey, Dr. Aziz is my doctor.
Oh, really? We know them.
Mohammed
Yes.
Aziz
Yes, sir.
and his wonderful wife. Yeah, they're very good friends.
We went to the same church.
Oh, do you?
Yes,
Oh,
we went to the same church. Yes. Sir.
okay. Well, yes, wonderful, a good family friend of ours. Yeah, and he's my doctor. Yes.
Yes, sir.
Well, but welcome and shukriya. Thank you for being here. Dr. Aziz teaches me some words.
I'd see. Are here.
An activity.
Hey, son.
I'm not gonna tell you the way is this. You speak like an Arab. Tells me that like an Arab. I don't know what's going to do. Okay, 23-41359 is called the state of Texas versus Robert Lee Stroud. Yes. Yeah, I would be too. It's never. That's a terrible. Okay, you are here with Mr. West, your attorney, right? All right. In cause number 23-41359, you were indicted back in January of 2023 for the third-degree felony of evading arrest or detention with the use of a motor vehicle. And you pleaded guilty to that charge in January of last year, 2024. We placed you on 10 years deferred or unadjudicated probation. I think you went to the Safe P program, substance abuse felony punishment facility. And you were ordered to go there and complete the program. Apparently that was not accomplished. And on May of last year, a year ago, a motion to revoke unadjudicated probation was filed by the criminal district attorney's office. And this is the motion that we are going to be dealing with. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Sean, please.
Mr. Stroud, this motion to revoke unadjudicated probation in summary states, and by the way, raise your right hand. Raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth, so help you God during this hearing?
I will be deemed to go, I don't want to talk to you.
All right. That's okay. Yes, that's affirmative. All right. This states that on January 25th, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for this third-degree felony of evading arrest or detention with the use of a motor vehicle. Is that true? I'm sorry.
Yes,
It is true? Yes, sir. Okay. Allegation one, the only allegation here it states that you violated your probation by failing and refusing to participate in the substance abuse felony punishment program as ordered by the court in violation of condition 12 of your deferred or unadjudicated probation order. Is that true?
I don't see why it's called a punishment that we
Okay.
making us on the law, we never did the law.
Okay, have a seat. Well, we're gonna have a hearing. He denies it.
Making up law.
You, sir?
I think y'all keep making up law, that's the law, and I'm late.
Let me ask you, John, is there something wrong? Do we need an examination or something?
He was just found,
Because I said.
Your Honor, on
that he was
April
incompetent.
11th,
And you-
from the Dunn Behavioral.
I still believe he's incompetent, but
Yeah.
the doctor says he's competent, so that's why we're here.
Yeah, well, I know, but he's rambling and is incoherent and it continues to rudely interrupt the court, which is against the rules. He's not following rules and he's mumbling and he seems incoherent. What do we want to do? Yes, you are, sir. When I speak, you have to stop or else you have to go back to the jail and you're put in detention. We don't want you to do that. Go ahead.
Your Honor, I don't believe he's competent, but the doctor's report and has ruled that he's competent, so
Can you explain, is there any explanation you can make for the way he is acting now, if he is competent, for the record? We've got to have something in the record that supports something other than the way he is manifesting
Your Honor,
himself now.
I will say that every time I spoke to him, it's very similar to this, that it doesn't make a lot of sense. It's incoherent. He is not very easy to communicate with. I still do not believe he's competent. And I know the doctor ruled that he is competent. I'm not a psychologist, don't have a degree in that, but I don't, you're not able to coherently understand what's going on.
I hear what you're saying, right, and the justice is coming on, like, just feel not guilty, what are you thinking, I feel I'm guilty. I ain't about it, it's just jail, it ain't me, man. You stay at the jail, I'm telling you, like, you educated. I'm educated, you ain't have to, man. I'll let you speak over me.
Don't be rude. Don't be rude. Don't be rude. Hold on. Don't say a word. This court's reading something. You'll be able to speak here in just a moment, sir. Thank you. Are you taking your medicine? They're giving you medicine?
Take no medicine, put it in word for BC powder.
They're not giving
you have a little bit coming straight off.
John, he's mumbling. I don't understand it. It's like in a different language. Is he taking his medicine?
He said no.
Is he being administered medicine?
I don't know if they're doing it or not, but he's not, according to him, he's only taking BC powder. Is the only thing he takes, that's all he needs.
BC, that's for indigestion?
That's kind of like a general,
I think for headache.
yeah, it's just kind of like a Tylenol.
See, it says here in this evaluation, and I'm looking at a report dated April 15th, 2025. a month ago. It was prepared by the University of Texas Health Center at Houston. And this is an evaluation of the defendant by signed by Dr. Daniel Doyle, Chief Operating Officer. It was a very lengthy report of a report of competency and attending physician's report of the defendant, signed by a psychiatrist, Nicola Polizzato, Polizzotto. And this report consists of 13 pages of single space text of the result of the analysis of the defendant and the opinion and recommendation summary on the last page of this report in the portion called attending physician's report of patient's progress. The treatment team's opinion of Mr. Stroud is he has achieved maximum benefit from inpatient hospitalization, and he should be returned to court as he is competent to stand trial. It should be noted at the time, no known prior history is noted, but at the Jefferson County Jail, while he was there before they had analyzed it, the defendant was described to be disorganized and internally preoccupied. Well, that's what he's doing right now. He was not started on medications and presented at DCB with no sign of improvement, appearing also grandiose. At first trial with Haldol, up to 30 milligrams daily led to just a partial response, and similarly, olanzapine up to 30 milligrams daily also led to improvement, but some degree of disorganized persisted. He entered Safe P and began his treatment, but quit it on April 22nd, 24. So he was reincarcerated in May of 24. He was prescribed olanzapine 10 milligrams, but it seems he was most recently non-compliant with taking his medicine because he seems disorganized and internally preoccupied, like he is now here. Given his history of partial response with failure of olanzapine, it was attempted to prescribe a combination of olanzapine up to 30 milligrams daily and Invega up to 12 milligrams. Again, disorganization with illogical, nonsensical statements or neologisms appeared difficult to treat. However, he made further improvement over what observed before, and while some disorganization persists, he is now able to communicate relevantly. His behavior seems appropriate, and he has displayed fair participation in the program. He has clear benefit from current medications. It is strongly recommended he continues to take psychotropic medications as prescribed. Currently, he is not a threat to himself or others, and a civil commitment is not being pursued. It seems like the issue is ensuring that his medication is taken. Are you taking the medication?
I'm not taking the medication.
You're not taking any medication?
I don't take it. I don't take it. I don't want it in my body. I don't want it
Okay.
in-
Did they give it to you though?
I take it at nighttime. I don't take the
How do you take it?
I take it with water.
With water? Okay. All right. Okay. So back to this. Back to this allegation. This states Mr. Stroud, you refuse to participate in the Safe Peak program as ordered. Is that true?
Yes, I ain't gonna tell you none of it.
You're not gonna do that? Are you pleading true to this?
Yeah, I'm trying to get this straight.
Voluntarily and because it is true?
Yeah.
Okay. Do you understand
Yes, I understand.
that, hold on, let me speak, that a knowing and voluntary plea of true, that is to a violation of program, probation, that is enough to grant this motion to revoke probation. Your probation could be revoked. You could now be found guilty and sentenced no less than 2 nor more than 10 years confinement in prison. Do you understand?
Should be time served for the offense.
Do you understand what you're facing?
Yes, yeah.
Because you've got a lot of time served. You got almost 700 days. Yeah, almost 2 years. Knowing that, knowing all of the consequences possible, do you insist on pleading true today like you've done? Okay. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true here. Go ahead, John. What are you asking for?
Your Honor, we're asking for, just like he said, we're asking for credit for time served. He's already done.
What are you asking credit for time served? Give me a number.
2 years.
That you're asking for the minimum.
2 years. He's gonna have credit to cover that, and I think that would be a fair number based on his offense.
Just looking for a pre-sentence report really quickly. Does anybody have on Daniel? Which I was just wondering what was criminal history is. What are you gonna do when you release? Where are you gonna live?
Back in my behind Jubilee about a mile.
Okay.
Go back over there.
Here's the criminal history.
And like you got a whole police right here, but I watch this beach this morning. I live, and I went beach, I live.
Okay, he's never been convicted. Looks like it was felony, huh? It's just been, he's been placed on probation for controlled substance violation and evading arrest, this one, and illegal possession of controlled substance twice. So he's been on 3 different deferred probations over from 2007 to 2022.
And he also had the, sorry, Your Honor.
Thank you. John, is that the review?
Yes, that's what I want to get the conviction of early convictions.
And he's got a numerous misdemeanors, but nothing, but they were only short terms in jail, resisting arrest. Okay.
So that's why I'm asking 2 years, because this is the kind of all.
Right.
It's not that.
What's state?
State would recommend 4 years, Your Honor. Just 2 third-degree felonies. I mean, that's kind of still on the lower end, but I'm recommending a 4 year.
And Mr. Stroud, anything you'd like to say?
No, sir.
Yes, sir.
Get to see what this level of my world and kind of where to the head, man. I mean, I got the head power to do it. I mean, finally, what I was saying, for real.
Okay. All right.
I think to translate a little bit about that, I think his issue is that he stays out of trouble, and on his probation, the only violation he does have is not going and refusing to commit a safety. He hasn't committed new offenses or anything like that. So I would understand his own.
Before I assess a resolvement in this case, the thing is that what we want to do is fix the problems. And if Mr. Stroud does not take his medicine, then he's going to be right back into, we're going to revolving door and something's going to happen here. Here, it was evading arrest and detention. He was, on this case, that he's placed on probation on, he's operating a 4,000-pound missile around town. Anybody feel safe with that?
I had my car.
I understand, sir, but a vehicle, I know a vehicle has to be operated responsibly. Yes, sir. And all right.
The other option is to continue on probation.
What's that going to do?
Yeah, so I don't think that'd be successful.
All right, here's what we're going to do. I'm going to find there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegation 1 has been proven true, as the defendant has admitted, that he has failed to participate knowingly in this SAFE-P program, substance abuse felony punishment program, as ordered in violation of condition 12 of his deferred or unadjudicated probation order. Early in this case, the defendant pleaded guilty voluntarily. He was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt. I now find you, Mr. Stroud, guilty of this third-degree felony of evading arrest or detention with a motor vehicle that you were placed on probation on, based upon this motion to revoke unadjudicated probation hereby being granted today in this hearing. And you are found guilty beyond a reasonable doubt of that underlying charge that you were placed on probation for. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And you will be given credit for all time you have served, which is 2 years. So it sounds like you may be getting out here.
8 more months ago.
No, not necessarily. No, nothing. You may be getting out pretty quickly here because you're parolable, and very few people stay in prison, stay in a jail for the whole time. You get parole, and parole is generously given. So you might be released here shortly, but you're going to be given credit for at least 654 days, which is right at 2 years. Okay. Anything else? All right. Good luck. Good luck to you, sir. Thank you. And
I think that please ready.
Hold on for a second. Hold on. Okay, you'll come on up. Hey, we got 2 cases here.
Right.
We only did one. So we've got another. I was dealing with 41359, the evading arrest or detention. He was also on probation for 23 CR 525, right?
That's correct.
I thought we were released together.
No, there's a motion to revoke that says that was filed here in 23 CR 525, where you were placed on probation for 10 years on January 25th, 2024 for illegal possession of a controlled substance. What was this? Anybody know? This. Exactly. Not much. I know that. I need a copy of the indictment, please. It's not in the file all of a sudden. Okay, it's methamphetamine.
1.092 grams.
Okay. And in this motion, it alleges as well, Mr. Stroud, just like the other one, that you failed to participate in the substance abuse felony punishment program. And again, you're still under oath. Is that true in this case as well? Yes, sir. And you're pleading true voluntarily, knowingly, intelligently, and because it is true. Is that correct? All right. And again, I'm going to find, as the defendant is aware, that a voluntary and knowing plea of truth is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. I so find the defendant has failed to honor the conditions of probation, condition 12, as we found in 41359, and that is found by a preponderance of the evidence or greater. Thus, this motion to revoke unadjudicated probation as well, in this case, 23 CR 525, is hereby granted. And if nothing further to state by the parties, the court finds that is enough evidence to grant this motion to revoke probation. Your deferred unadjudicated probation in this case is hereby revoked. Earlier, you had pleaded guilty voluntarily to this case when we placed you on probation. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty at that time as well. And there was sufficient evidence supporting your plea to find you guilty beyond a reasonable doubt. Now that your probation is hereby revoked by the granting of this motion to revoke probation, in this case, your deferred or unadjudicated probation is revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. In this case, these two sentences shall run concurrently together at the same time. Do you understand what has happened in this case, sir? All right, good luck to you. Kate, take your medicine. Thank you. On Renata Taylor, come on up. Stay. I find you are indigent. An attorney will be appointed to represent you. In your case, and we'll get one of the public defenders on Miss Taylor's case. All right, and that please get a resetting. Thank you, ma'am. Parole, Atia.
That you've got a plea in the cause number ending in 26, or I'm sorry, 66, and a dismissal in the other case. Yes, sir.
Right. Come forward, sir. We now call two cases, 24 CR 266 and 24 CR 53, the state of Texas versus Harun Atia. Is that you?
Yes, sir.
Present with your attorney, Mr. Atia, and the state's attorney. Does the defendant waive a formal reading of the indictments and the arraignments here? Can we proceed in summary? And we'll begin with 266. He will be pleading guilty to this, and I understand it was a condition as part of the plea agreement, 24 CR 53 will be dismissed.
Yes, Judge, and I also need to ask the court to note that in the terms sheet when you get there, because I forgot to.
Okay. In summary, 24 CR 266 alleges that on or about January 3rd, 2024 in Jefferson County, Texas, you committed the state jail felony of engaging in organized criminal activity. Looks like gambling promotion. Do you understand what you are charged with in this indictment, which is a state jail felony?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And an agreement's been reached, you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years. And there is no fine. There will be terms and conditions of probation, which are normal and customary for this.
And this is where I need to add, and we're agreeing to dismiss cause number 24 DCCR 0053.
Factory will be dismissed as part of this agreement. Is that your understanding?
Yes, sir. Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment here in 266, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, and it's being made freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
All right, State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, if nothing further, and I'm going to find you, sir, are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt.
Yes, sir.
But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you listen closely, follow these terms of probation, which can be shortened to 1/3 by good behavior. If you fail to follow these terms and conditions of probation, you see what has happened by another case here. Your probation could be revoked and you could be sentenced up to 5 years in prison. So it's important. Follow the 2 years, 2 years in the state jail. 5 years, 2 years in the state jail, 5 years probation is the most that you can serve in probation. But again, we will shorten that and reward you. Please see the probation officer and make sure you understand all the terms. You will begin. The quicker you start, the quicker it all ends. Yes, sir.
Yes, sir. Judge, Mr. Eckhart stated that I could make an argument to you in regards to the years, in regards to the 5-year deferred that Mr. Eckhart essentially offered, but I would ask you if you would consider anything less. 37 years old, judge, one child, he's working gainfully.
He does well, and I shorten him to 1/3. And that's 1 2/3 years.
Yes, sir.
I do that. That's what my more normal practice is, and there's no reason that yours should be any different.
Yes, sir.
Yeah, and because we don't need people on probation longer when they are doing fine, and the probation office recommends it. We shorten it all the time,
Yes, sir.
and I'm certain it would be the same in your case.
Yes.
Okay.
Thank you, Judge.
Thank you.
We've submitted a dismissal in the other case, Judge.
Thank you, Your Honor.
Yes, thank you, sir. And I've got 24 CR 53 before me. That case is hereby dismissed.
Thank you, Judge. Yes, sir.
Yes.
Yes, ma'am. Thank you.
Okay, thank you, Mr. Happy.
Thank you. Can I
All right.
have the other file, please?
All right, short recess and let's get ready for trial.
So you can call the clerk's office and give it, or let me give you the public defender's office number.
Okay.
It's area code 734.
Yep.
222-6970. Call them, give them your updated phone number, as well as making sure that your email that they have is correct, and then you'll be all set.
Okay, yes. Thank you, Your Honor.
Thank you.
Thank you, sir. Thank you, Your Honor.
Court calls case of the people versus Isa Awad.
I'm gonna enter a not guilty plea. I'm gonna enter a plea of denial and no proof of insurance. I'm gonna give you a $500 personal bond.
I'm here.
Conditions. You cannot leave the state
I'm
without the
here.
consent of the court. You cannot violate a law. You must appear in court.
I'm here.
Oh, there's Miss Ford's here.
Yes, Deborah Geraldine Bledsoe Ford on behalf of Isa Awad.
All right. And Mr. Awad?
Yes, Your Honor.
All right. I need you to turn on your camera, state your name.
Isa Awad, and my camera's not working. Give me 1 second. I fix it.
Okay, well. All right, and Miss Ford, you can verify that that's your client?
Yes, that's my client.
All right, what are we doing?
I'd ask that the matter be continued to June 18th. I would at 9 appear in person. My client has stated all along that he wants a jury trial, and I'd like to talk to the other side and see if we can negotiate anything. If not, then go further.
Can't do that by the 4th?
I feel it would be a strain.
June 18th, 2025, 9 a.m.
Thank you
That's gonna
very
have to
much.
be in, that's gonna have to be in person because he doesn't have a camera.
I'll be in
So that
person.
here, that hearing's in person.
We will be in person. Thank you.
Thank you.
Thank you, Your Honor.
Oh, no, let's get this done. Court calls. Cases of the people of the state of Michigan versus Jason David Allen. All 9 of his files.
Ashley Lonnie for the people in all matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom from Dawn Parham. Sir, can you please unmute and state your name for the court?
Jason Allen.
Thank you, Your Honor. There is a resolution of all 9 of these matters today, Your Honor. I don't know if Ms. Londi would prefer to put the resolution on the record, or I could do so.
I am happy to do that. Your Honor, chart 22410696, the defendant will plead no contest to this charge to retail fraud in the 2nd degree.
Hang on, which case?
696.
696, he's pleading no contest.
As charged.
As charged, all right. Got it?
698.
Yes. He's doing what?
No contest to an added count for retail fraud in the 3rd. Dismiss count 1, count retail fraud 2nd.
That's no contest to that charge also.
Yes, sir.
They're all no contest
Yes.
from the reports I read. Okay, I hope they are. All right. Go ahead.
697.
Yes.
He'll be pleading no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
All right. Okay.
328.
Yes.
He'll plead no contest is charged to retail fraud in the 3rd degree.
Okay. Okay.
And lastly, 278.
Yes.
He'll plead no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
Okay.
Case 699. And don't please, the dismissal cases now, will be 699.
700 and 19, 2419, and then 218 would be dismissed.
That's correct. Restitution for all cases and all counts.
So basically, he's pleading to 5 counts of retail fraud 3rd degree.
1 retail fraud 2nd, 4 retail fraud 3rds.
Okay, hang on a second. Got it. Okay, 696, he's pleading to retail fraud in 2nd degree.
Exactly right, Your Honor.
Why, I don't know, but is that correct? Is that a correct statement?
Yes, it is, Your Honor, and that is what I discussed with my client, and that is what he would like to do today.
All right, Mr. Allen, raise your
Yes,
right
sir.
hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please, sir.
Jason Allen.
All right. Mr. Allen, it is this court's understanding that you are going to be pleading no contest to 1 count of retail fraud in the 2nd degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
And that also you'll be pleading no contest to 4 charges of retail fraud in the 3rd degree. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. That's greater than $500, that would be the maximum fine. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right, two things about a no contest plea is that I have to make sure that you understand is that first of all, it means that you're not further desirous or wanting to contest any of these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea in these cases?
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud, second degree, how do you plead?
No contest, Your Honor.
To the charge of retail fraud, third degree, as contained in the case ending in 698 with an offense date of March 12, 2024, how do you plead?
No contest, Your Honor.
To that same charge of retail fraud in the third degree, contained in the case ending in 697 with an offense date of March 17, 2024, how do you plead?
No contest, Your Honor.
To the charge of retail fraud, third degree, as contained in the case ending in 328 with an offense date of 8/29 of 2023, how do you plead?
No contest, Your Honor.
To retail fraud, third degree, as contained in the case ending in 278 with an offense date of November 27, 2023, how do you plead?
No contest, Your Honor.
All right, now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am a participant of Judge Kunke's drug court.
All right, so you're on probation. Well, were you on probation at the time of any of these offenses?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report in the case ending in 696, the report number 23-14001. In the case ending in 698, the public safety report and case number 244086. In the case ending in 697, court has reviewed the police report 244362. In the case ending in 328, court has reviewed the police report and police report case number 23-12936. And in the case ending in 278, court has reviewed police report ending in 23-18100. Since I've read all those, counsel, is there any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
All right, the court in each of those reports does find a sufficient factual basis in which the court could find the defendant guilty of the offenses as alleged for sufficient evidence of defendant's guilt in those cases. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas in all of these cases to count 2 or to retail fraud second in case 696, and in the other matters to retail fraud third. The other cases, as indicated on the record, are no longer with me. Those matters are dismissed. All
Thank
right.
you, Your Honor.
Defendant is referred to probation for pre-sentence investigation and report. sentencing in these matters will be June 25th, 2025, 9 a.m. Defendant's bond in all of these cases will continue. Mr. Allen, I need you to wait online. We're going to put you into a breakout room with my probation department so that we can begin the sentencing process. Okay, sir?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Allen.
Thanks, Natalie.
What's on that?
The dismissals.
Court does call the case of the People versus Lisa Keebler.
Ashley Lonnie for the people.
It's only 9 or 10. Oh, yes, I see that.
Good morning, Judge. John Shea with and on behalf of Ms. Keebler.
Your name?
Lisa Keebler.
Thank you.
May we approach?
Yes.
Thank you.
I've still got, is your,
Should be on Zoom, Judge. She was on Zoom, then got kicked out for some reason, probably something from the restaurant button, and now she's getting on back again.
She's,
you have her?
she was, she is not currently.
All
I
right.
just resent her the Zoom ID again. She got. kicked
We'll,
out, Judge.
we'll get you if there's anything I can do from that block and then before I take a break
Yes.
and try to
I
get some
can
of these
give
folks
you
out.
these,
So we don't fall.
And I can start calling in custody if you want.
Let's just roll while we can. Court calls the case of the People versus Nadia Cosley. Good morning, sir.
Ashley Lonnie for the people.
Yoo-hoo.
Oh, this- What was the picture on it?
Cosley.
In the 10 a.m. block. Oh, that's me. I'm sorry, Your Honor.
No, it's okay. You guys were in some, I don't know what kind of conversation you were in. You were in some conversation. I was willing to wait. The only reason I said anything is because of Alan. No.
Well, thank you, Alan. I appreciate the heads up. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Cosley, who should be on Zoom.
She is.
So we're here for one, well, I'd ask her to state her name first, please. Ms. Cosley, can you unmute and state your name for the record?
Nadia Cosley.
All right.
So we're here for pretrial, and then there's a,
There's another case.
correct. We've waived formal reading and stand due to those charges, Your Honor.
All right. On our other matter, that being the case ending in 513, defendant waives formal reading, stands mute. All right.
And then as for pretrials, I'd ask for an adjournment of both cases. She's working on getting her license back.
Okay, where is she in that process?
Ms. Cosley, do you know what you need to do to get your license back?
Yes, I just have to pay my insurance ticket. I got it suspended because I didn't pay the ticket. I'm just working with my manager to get my money.
Oh.
I've just been working. I'm in college and I'm paying rent.
Hold on.
So I'm just getting the money to pay the
You said a
ticket.
lot there. Hold on a second.
I'm sorry.
No, it's okay. So you got to pay the insurance case because you're suspended because of that, right?
Yes, because I got into an accident with no insurance and I never paid the ticket.
Got it. And that's the ticket we just arraigned her on? Or is it another?
There's another no insurance, I believe. But I have insurance now. I have car insurance now.
Still infraction, no food insurance.
Yeah, she didn't pay that ticket, so then Secretary of State suspended.
Suspended her license and now we have this new one.
Yes.
Okay. All right, so how much time is she gonna need to straighten this whole mess out she's created?
And I will say for the record, she does now have insurance on the vehicle.
Oh, okay, well, good.
Right, so she's making progress. She just has to get the money to pay that ticket off.
To pay that ticket off. Can she do it by the 18th of June? Subway pays well. She'll get it.
My birthday
June
is also this week, so I'll get birthday money.
What'd you say?
My birthday's next week, so I'll get birthday money.
Oh, well, happy birthday.
Thank you.
June 18th, 2025, 9 a.m. Bond continued. All right, thank you. Well, I'll have to set a personal recognizance bond in her other matter. I'll just give a personal recognizance $5,000 bond. All right, thank you. Court does call the case of the people versus Sean Chernley.
Kind of, so on behalf of Pittsfield Township.
And Ashland.
Which one's in the ring?
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Charnley. Mr. Charnley, please state your name for the record.
Before we go on to the other case, Mr. Chernley, you have a new matter before me. That case alleges that on or about March 24th, 2024, at the location Carpenter Road in Pittsfield Township, that you did possess drug paraphernalia. You understand the nature of that charge, sir? I do. And that's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that, sir? I do. All right. Do you wish to be represented by an attorney? I do. All right. This is a public defender case.
Your Honor, pertaining to the arraignment, we'll waive formal reading and stand mute to the charges.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea.
As for all the pretrials, we're asking to adjourn all of them. Mr. Charnley is up in court, and we're kind of just seeing what happens on those. His next dates on those are June 5th.
Right.
Well, he has some May 29th. The latest date is June 5th. So I'm asking,
June 18th date.
yeah, I'm asking
What a date after those.
after June 5th, right?
All right. So, well, on his new case, I'll order standard conditions, no assault behavior, no possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. I'll adjourn all of these matters then to June 18th, 2025, 9 a.m. Bond and the other matters will continue.
Thank you, Your Honor.
Thank you.
I did not, 5,000. 10%. She's, okay, hang on, let me do this one real quick. Court calls the case, people versus Billy Cobb Gully.
Ashland for people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cobb Gully, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Billy Cobb Gully.
Thank you, Your Honor. As to the case itself, there is a resolution to which my client will be pleading no contest to the added count 2 of OWI, and in exchange, count 1 will be dismissed.
That's correct, Your Honor. That added count 2 of operating while intoxicated first offense, 93-day misdemeanor, $100 to $500 fine, 6 points and various license sanctions is contrary to MCL 2576251A. I believe it will be a no contest.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right, state your name for the record, please.
Billy Cobb Gully.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of operating while intoxicated, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
That is correct.
Any question regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right, the court has been handed in, or has been provided and has reviewed Michigan Department of State Police report for their case number 9303-24. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond with its conditions will continue. Mr. Gully, wait. I need you to wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process. All right, sir?
Okay, thank you.
All right, thank you.
Thank you, sir. Thank you, Your Honor.
Thank you. Court calls the case People versus Stephen Grisbeck.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Grisbeck.
What are we doing?
Your Honor, we're asking for an adjournment of this pretrial of the possession of drug paraphernalia case.
Okay.
He's currently serving a sentence on his domestic violence case. I've been in communication with, and just, I guess, for the court's knowledge and Mr. Grisbeck's knowledge, I have been in touch with Ms. Pilara. He's at risk of losing his Section 8 housing. I know Mr. Bernstein handled that DV case. I know the court's aware of that. So she may, if he continues with the domestic violence classes, may move up his review hearing to June. May recommend that the court.
We were trying to move his case closer so his certificate or in the house wasn't in jeopardy.
I have 9 days before the 93 days is up.
I have him in custody for 55.
Your sentence is up in 9 days?
The voucher.
Oh, the voucher. You have 9 days left on that.
Are you saying that because of the amount of time you've been in custody?
So how much longer do you have on the DV classes? I'm doing the ones in jail.
Yeah, I already did 5 classes.
How many are there?
There's 12-week class. I've already done 5 of them.
You're about halfway through.
Correct.
All right. So I know we were trying to get him to a certain point so that he didn't lose that, but so I'll adjourn this pretrial to June 4th, 2025, 9 a.m. I don't want to go, if we have to do another adjournment, we'll do it, but you've been in contact with Ms. Pilara.
Yes.
Okay. Okay. have, I don't know where you guys are in your discussions, but then have Ms. Blair get in touch with me so we can see if we can maintain his housing security.
Okay,
Okay,
I appreciate it. And if I may ask, is his bond on this case a personal bond? If we do resolve the DV case?
Kind of just handed off the investigation to Kyle Gapin. The offense listing the defendant as a victim in the case. And he listed Mark Clanton as a suspect for obstructing a roadway. You're also going to hear evidence that that report and conclusion was not supported by law at all. Now, the case gets transferred to different detectives for follow-up, and they receive video evidence in the case. And when they review that evidence, they say, hey, obstruction was not a legally founded charge here. An aggravated assault has occurred. They conduct further investigation, reviewing videos, taking statements from witnesses, and that is how we end up here today. The defendant did commit the offense of aggravated assault with a deadly weapon, and she also committed the offense of injury to an elderly. You will hear testimony that Mark was 68 years of age on the day that this offense occurred. And at the end of this trial, we are confident that you will find the defendant guilty. Thank you.
All right, defense, do you have any opening statements?
Yes, Your Honor.
You may proceed.
Morning. This is a situation where my client lived next door to the Clantons. The houses are very close together. There's a curb in front of the houses. There's two, I'm gonna call them trash cans, and I'm sure one was a mulch bin or recycle. The one that you're gonna see that's closest to my client's house is also a place where the curb goes down to the street level and goes back up. That occurs so that water can come out between the houses. On the date that this incident happened, it's on a Saturday. There's no trash pickup on a Saturday. Mr. Clanton goes out and puts empty trash cans out there, blocking her place to park. He knows she always parks there. She comes back from an event. She tries to park. She stops her car. You're going to see that when she stops her car in that, and this is very hard to see from the video because the angle of the video, there's trees in the way, all kinds of things in the way. So what you're going to find though is that she stops in the wheel of her car is at that point on the curb where it's closest to the ground, just barely. She stops the car, gets out, carefully moves the cans behind, puts them in front of the house, gets back in the car, starts moving forward, not accelerating, moving forward. This guy comes running out of his house, grabs the cans, comes out, almost jumps in front of the car. The officers on the scene, not just one, but all of them, they saw the video at the scene. And they determined that he was responsible. They wrote up the report that way, and they went over and chastised him for it. So we're going to write you up for obstruction. You don't jump in front of a moving car. You just don't do that. Okay. Then 11 days later, he gets photos taken of the alleged injuries. 11 days later. This detective gets involved. I'm not really sure what happens as far as his, what's going on with him. I just know that he changes the whole report. Now he says, well, she's responsible, aggravated assault with a deadly weapon. She must have had the mental intent to run this guy over, or at least injure him, which requires a mental culpability. There is no mental culpability in this case. There's no crime in this case. And we believe that's what the evidence will show.
At the end, we're gonna ask you to find my client not guilty. Thank you.
All right, state you may call your first witness.
The state calls Officer Kyle Gapin.
If you can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear and the court reporter can hear. If you'll state your name for the record, please.
Kyle Gapin. Gapen.
All right, state you may proceed.
Officer Gapin, how are you currently employed?
I'm employed as a peace officer with San Antonio Police Department.
And is that a certified peace officer?
Yes, ma'am.
How long have you been employed with San Antonio Police Department?
For almost 2 years.
Can you explain to the jury the training you underwent to become a law enforcement officer with San Antonio Police Department?
We went through a 9-month academy with double the state's required hours for license certification.
What type of things did you learn in the academy?
Traffic law, penal code, CCP, arrest or seizure, and then tactics and shooting, driving.
Once you complete the academy, what is the next step in your training?
We go on a 3-month FTO period. So each month is at a different station with a different FTO. And if you progress to each, like phase 1, then you go to phase 2, phase 3, and then you have a 2-week period where you're evaluated without the assistance of an FTO.
And just so the jury is aware, does the FTO stand for Field Training Officer?
Yes.
And is that an officer that is more senior than the person that he's training?
Yes.
Okay, and so when you're in this FTO program, are you considered a probationary officer, commonly known as a probie?
Yes.
Okay. What is your current title and assignment with SAPD?
I am an officer and my assignment's on North B shift.
And as a officer, what are your duties?
To protect and serve, patrol the area given, my districts and the service area.
Okay. When you say patrol, does that mean respond to calls for service where citizens are calling 911 for help?
Yes.
Okay. Now I want to turn your attention to October 21st of 2023. Were you employed as a police officer with the San Antonio Police Department on that day?
Yes.
And about how long had you been on the force at that time?
As a licensed peace officer, less than 1 month.
Okay. And so were you in your probationary period at that time?
Yes.
And what shift were you working on that day?
North daylight, or North A shift.
And what hours does daylight run?
I think it's 6:30 to 1:30.
Okay. Were you in uniform on that day?
I was, yes.
And were you in a marked patrol unit?
Yes.
Okay. Did you respond to a call for service on that day?
Yes.
Did you write a report associated with that call?
Yes.
Would it help you refresh your memory if you were able to review a copy of that report?
Yes.
Showing you what has been marked for identification purposes as State's Exhibit number 1. Do you recognize this?
Yes.
Were you the author of that document?
Yes.
And is it a fair and accurate depiction of the report that you generated on October 21st, 2023?
Yes.
All right, you're able to refresh your memory. Please don't read from So can you please explain to the jury what address you responded to, on October 21st of 2023?
It was 13903 Flairwood.
Is that located in San Antonio, Texas?
Yes,
And is that located in Bexar County, Texas?
yes.
What type of location is that?
It's a residence.
Do you recall why you were dispatched to that residence?
It was an accident.
And is the SAPD case number associated with that call SAPD 23236613?
Yes.
Once you arrived on scene, who did you make contact with?
I believe I made contact with the defendant.
Okay. And can you just describe the scene that you observed upon arrival?
So there was a truck, garbage cans to the side of it, and then an individual that was on the ground, and then the defendant was back by her house, and we went to go because there was an officer that responded first. We talked with him, and then we switched over to speak with the kind of exchange and go to the defendant.
Okay, what type of vehicle, or you said you saw a truck, is that correct?
Yes.
What type of truck was that?
It was a Ford pickup truck.
Do you recall what make and model it was?
It was a 350.
Okay. And so you make contact with the defendant, is that correct?
Yes.
All right, and then did you take statements from anybody else on scene?
Yes.
Who was that?
From the victim
Oh.
of this one.
And so in your report, who did you list as the victim in your report?
In my report, the defendant was the victim, and the current victim of
Okay.
switched.
I'm gonna have you use names, so.
Okay.
In your investigation on scene, who did you determine to be the victim in your opinion?
Darren Johnson.
Okay, and who did you determine to be the suspect from the limited investigation that you did on scene?
I think his name was Clayton, Mr. Clayton.
Okay. And was there video evidence that you were able to observe on scene?
Yes.
Okay, and how did you view that video evidence?
Through a cell phone.
Through a cell phone?
Yes.
Okay, and what size was the screen?
I think it was an iPhone, so I don't know, 3x2. I don't really know the dimensions.
Okay. And then after taking all statements, what type of report did you generate?
I generated an obstruction of highway report.
Okay. And what was the reason that you did that?
I felt that after watching the video, Mr. Clayton had obstructed the Miss Johnson from driving her vehicle.
Okay. What is the legal definition of obstruction?
To impede passage.
Impede passageway and render it impassable, is that correct?
Yes.
All right, and so you've had an opportunity to view the video evidence again, correct?
Yes.
And in viewing that video evidence, was the passageway rendered impassable?
No.
Okay.
Judge, I'm gonna object, that's a legal conclusion.
That'll be sustained.
May disregard.
Ladies and gentlemen, you're to disregard the last answer that was given by the witness. Does everyone understand? Thank you.
In watching the video evidence, were there other areas of the street where vehicles could pass?
Yes.
All right, so, excuse me, to the witness.
That's okay, Judge.
No, I just want to explain something, because I know sometimes people are not used to testifying. If you ever see any party stand up, don't answer the question because they're about to make an objection.
Yes, ma'am.
All right, you may proceed, state.
And the reason that you took this report, is it because you were trying to gain
Leading judge.
experience?
All right, let me hear the question and then I'll hear your objection.
What was the reason that you decided to take the report writing responsibilities as a probationary officer?
Yeah, to gain experience for the call, we were assigned to that call in order to satisfy training objectives for a motor vehicle striking a pedestrian.
We pass the witness, Your Honor.
All right, defense?
Good morning, officer. My name is Robert Porter. I'm gonna ask you a few questions. Can you hear me? Okay. I'm gonna ask you a few questions. If you don't understand them, just say, I don't understand them, okay? Now, probationary officer, you had already gone through a lot of training, is that right?
Yes, sir.
Now, let me ask you a couple of things. When you arrived on scene, you talked to the complainant, I guess. Well, you talked to both parties, is that right?
Yes.
Nobody else was out there on the scene when this happened, is that right?
I don't think when the incident occurred.
When the incident occurred?
No, I don't believe anyone was out there, but people did come out to assist. There were several people around.
Okay. After the fact. Other people showed up after the fact, right?
To my knowledge, yes.
Okay. So when you were at the scene, you had an opportunity to view the scene, is that right?
Yes.
And being a rookie, I guess, and I don't mean to just downplay you, but being new to the job, you took extra care because you're being judged on how you write reports, is that right?
Yes.
Okay. So being a good officer at that time, you watched the scene, looked at the scene, is that right?
Yes.
Okay. Now, would you agree with me that you also looked at the curb where the trash bins were placed?
Yes.
Okay. And you'd agree with me also that that curb isn't a raised curb throughout the whole thing. There's actually a dip in the curb that goes to street level and then they come up. Is that right?
I believe like at the driveway area, if that's where you're talking about.
Well, there's the driveway area and then there's the area right between the two houses. There's a dip, right?
I don't remember if there was.
You don't remember that?
No.
Judge Matt Roach?
Yes.
So I'm going to show you what's been marked as defense exhibit number 1. Okay. Now you mentioned in your report. Well, let me ask you this. Do you recognize this photo?
Like the location in the photo?
Correct.
Yes. Yes.
Okay. Do you recognize that?
Yes.
Okay. Now, what does that alleged to have shown?
That there's a dip in the curb.
Okay. Now, is this picture the location where this happened?
In the general area, yes.
Okay. And you had mentioned the address?
Yes, this is, I believe, Mr. Clayton's address.
Okay. Has this been altered or amended from the date you were there in any way?
I don't believe so, no.
Okay. This time, Judge, we're gonna offer state's the defense exhibit number 1 tendered to state for any objections.
No objection.
Right, defense exhibit number 1 is admitted without objection.
Okay. So you've agreed with me that there's that dip in the sidewalk. Now, this happened on a Saturday, is that right?
I'm unfamiliar with what day it was.
October 21st of 2023. Do you have a cell phone with you?
I do, yes.
Pick it up. Scroll through your calendar.
Judge, I'm going to object to lack of personal knowledge and relevance.
All right, that will be overruled.
You can look up October 21st of 2023.
Yes, it is a Saturday.
Is there trash pickup on Saturdays?
I'm unfamiliar with that area.
There's no trash pickup on Sundays either, is that right?
Again, I'm unfamiliar. I figured neighborhoods do it differently.
Are you aware of the city ordinance that says you're not supposed to be putting out your trash bans until within 24 hours of the date it's supposed to be picked up?
I was unaware of that, no.
Now, when you showed up, you're getting different versions of what happened, is that right?
Yes.
Okay. But you were actually able to watch a video of what happened. Is that right?
Yes,
Now, once you watch that video matched what Ms. Johnson was telling you. Is that right?
for the most part, yes.
So let's kind of walk through it a little bit. Is that right?
Okay.
Okay. So these bands were placed right at the edge of the one house and then right at the edge of Mrs. Johnson's house. Is that right? Because they're neighbors.
Yes,
You can see Miss Johnson. Let me ask you this: that pickup truck, it's a big old 350. Is that right?
yes,
It's a big vehicle. You'd agree with me on that?
Yeah.
So she pulls up, right? And in order for her to go forward to go in front of her house, she gets out of her pickup and then moves the trash cans. Is that right?
yes.
Now, these trash cans weren't moved to the other side of the property. They were actually moved into his driveway. Isn't that right?
I don't know where they were moved. I just know that they were moved off of the roadway.
And at that point in time, all you're seeing is Miss Johnson. Is that right?
Yes,
But then at that time, what you see it, if you look closely at that picture that I just showed you, that the pickup truck she had pulled in. Front tire was on this edge right here. Do you agree with me on that?
I don't know.
You don't remember?
I don't remember, no.
So what you did see though, and at the time you didn't know who it was, but you see a man moving quickly, grabbing a blue van and quickly moving toward that curve. Is that right?
Yes,
He was in a rush. It wasn't like I'm just kind of sauntering, right? And as he's doing this, that video also shows Ms. Johnson getting back into her truck. Is that right?
yes.
Is it generally a good idea when you're gonna pull out or go forward to check your blind spot?
Yes,
So what that video shows, it's a bang bang situation, isn't that right?
yes,
And in fact, what you see is the truck going forward. It wasn't racing forward, right?
it was not.
It was just pulling forward,
Yes,
right? But what you do see is Mr. Clayton, is that how you pronounce it? Clanton? You do see him coming very fast toward the front of the truck, right? With his dumpster.
yes,
And then you see the truck kind of go up.
yes,
What you don't see is the truck's tires turning.
correct.
They're going straight.
Yes,
Okay. And at that point in time, what you see is just a bang. She stops right away and then you see him fall down,
yes.
right? Okay. Now, in speaking with this, so once you saw that, once you saw that, have you reviewed that video before your testimony?
Yes.
Okay. Can you tell from the video whether the pickup truck hit him or did it hit the dumpster?
Honestly, I don't know that. I mean,
We don't know,
Yeah.
right? We don't know. But what we do know is we see Miss Johnson get out of her truck right away, right? She walks around, sees him there, he's yelling, and she calls police. Right?
yes, I believe she was one. Yes,
You talked to everybody that day on the scene on the 21st of October. Is that right?
for the most part, yeah.
You watched that video on the 21st of October, correct?
Yes,
You viewed Mr. Clanton on the 21st of October. Is that right?
yes.
You didn't see any injuries on him.
I did not, no.
Now, based on that, you, in fact, you looked at everything, and I'm not asking you to draw a legal conclusion, but you looked at everything, right?
Yes.
Okay, based on what you saw with just on the video, let's take away what everybody's editorialization is. Based on the video, what you saw was an obstruction. Is that right?
Yes.
Okay. And that obstruction was because you saw this gentleman going fast, trying to place it in front of a moving vehicle.
Yeah, and or himself, yeah.
Or himself, right? Is that a safe thing to do?
No.
The smart thing to do?
No.
One minute. How many more officers showed up at the scene?
Including supervisors or just officers?
Well, let's just start with the officers. How many officers?
Okay. I think at least 4 others that were there besides me and my FTO.
And then you said other people showed up?
Yeah, there was 1 supervisor that showed up.
Okay. Who else showed up to the scene while you were there?
EMS showed up, was there.
And EMS also showed up at that point in time?
Yes.
Do you remember if the EMS took him to the hospital?
They did not.
You weren't the only officer that viewed that video on the 21st of October, is that right?
Yes.
Who else viewed that?
My FTO.
For the jury's edification, FTO is field training officer?
Yeah, my field training officer.
Were you in the same car you're riding with him?
Yes, sir.
You weren't discouraged by him to not write the obstruction.
Can you
In other words, he didn't say, no, don't write an obstruction.
I'm gonna object to hearsay based on what the officer is telling him.
All right, that objection will be sustained as to hearsay.
Okay. Needless to say, does your field training officer, does he review your reports?
Yes.
And after review, you never changed your report?
No.
Once you're done, because I guess you wrote the report because you're considered what's called the lead officer, is that right?
Yeah, so because I took the call for training purposes, that I would handle the call, be the handling officer.
So it's your responsibility. Let me ask you this. Between you and the detective, what are the responsibilities change?
Just me and any detective, or
Okay, so
like in the general sense?
I'm sorry to interrupt you. Let me clarify that a little
Yes.
bit. So your duty that day was you went there, right? You viewed the scene. Would you agree with me? Viewing the scene is extremely important.
Absolutely.
And so it's imperative that you go there to see what's going on.
Yes.
Okay. You talked to any potential witnesses. Okay.
Yes.
You looked at everybody.
Yes.
You looked at the evidence itself. Is that right?
Yes, I did.
Okay. You wrote your report, and that report, there's nowhere in there about an aggravated assault, right?
Correct.
Based on that, you passed the case off. Is that right?
Yes.
You said, who was the first officer on scene?
I believe his name was De Leon.
De Leon?
I think so.
You know if he wrote a report?
I don't know if he wrote a report or not.
Is it common that when officers show up at a scene, do they all write reports?
It depends on what happens on the scene.
Okay.
So
No, go ahead.
I was just gonna say, sometimes we're prompted to write reports. Sometimes if it's a certain level of an offense, or if it involves another officer, or if there's a use of force or something like that, all the officers on the scene, even if they didn't make contact with anyone, if they were just patrolling around, they would just indicate I did nothing, basically.
Okay. So let me ask you this.
Yes.
When you write your report, is that just your own personal knowledge, or do you take into consideration what all the other officers, if you all talked about it, decide to write you?
Yeah, it's a collective effort. Everyone's kind of working together.
So on the 21st of October, the collective effort of all the officers there, right? It was an obstruction case.
Well, between me and myself and my FTO, we were the kind of people we were interacting with. Yeah, that's what we concluded.
I'll pass it.
State?
Further questions?
All right, is this witness excused or subject for recall?
Excused by the state.
All right, you may step down. Please leave the exhibits and the, with the court reporter. Are you able to get the exhibits? All right. All right, thank you. All right, state, call your next witness.
State calls Officer J. Del Leon.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. If you'll state your name for the record.
Officer Jesus de Leon.
All right, state, you may proceed.
Officer Del Leon, how are you currently employed?
With the San Antonio Police Department?
Are you a certified peace officer?
Yes,
How long have you been employed with the San Antonio Police Department?
5 years.
Okay. And what kind of training did you undergo to become a police officer with SAPD?
During the training at the Police Academy, we were trained in the Code of Criminal Procedure, the Texas Penal Code, mechanics of arrest, scene management, firearms training, driving training.
And the training academy, is it about 9 months? Is that
Yes, that's correct.
okay? After you complete the academy, what's the next step in training?
The next step is field training, which consists of being out in the field for several months, 1 month at a time with a training officer who's an experienced officer that has been on patrol for a number of years and has that certification. You'll be with that training officer 1 month at a time, learning how to handle the calls out in the field under their guidance.
Okay. What is your current title and assignment with FAPD?
I'm a patrol officer in the North District area.
What are your duties as a patrol officer in the North?
Handling a lot of the calls that were dispatched to, domestic disturbances, family violence, assaults, handling crash accidents, the highways, local roadways, patrolling around school districts, especially during school times, and doing on-site activities for things that we deem to be not right or suspicious.
Okay. Now, back on October 21st of 2023, were you employed as a police officer with SAPD?
Yes,
And was your title and assignment the same as a patrol officer with the North Substation?
yes,
And were your duties the same as responding to calls for service?
yes,
Okay. And on that day, were you dispatched to a call for service?
yes.
Do you recall the SAPD case number associated with that call?
I do not recall it right at the moment.
When you respond to a call, can you explain to the jury what a key card is?
The key card is the information that becomes available on the screen computer that's in the patrol vehicle. It's where the information comes across for the address that we're going to and what the call is coded out as, meaning what type of call am I responding to? Is it an accident or an assault? And it has some details that may have been provided that will be relayed at the bottom of the screen, which shows maybe what is going on with victims or suspects or vehicles involved. And that provides us some information as we're driving to the scene.
Okay. So was there a key card associated with the case that we're here for today?
Yes,
Would it help to refresh your, and did you make entries on that key card on the day of?
yes,
Would it help you refresh your memory if you were able to observe a copy of that?
yes.
I'm showing you what's been marked as State's Exhibit number 2. Do you recognize this document?
Yes,
Okay, and is that your name on the document?
yes,
And are those the entries that you made on the document?
yes,
And is this a fair and accurate depiction of the key card as it was on the date of the offense?
yes.
Okay, if you need to, you can refresh your memory, just please don't read from it. So can you tell me, is the SAPD case number associated with the call that you were dispatched to? SAPD 23236613.
Yes.
And when you were dispatched to the location, do you remember, were you first on scene or were there other officers there? Can you explain that to the jury?
I was the first officer to arrive on scene.
Okay. Can you please describe to the jury the scene that you encountered upon arrival?
Yes, when I arrived to the location, I exited my vehicle and I started walking towards the grassy area. I first observed a white truck that was parked curbside in front of the address. And male was laying on the grassy area adjacent to the curb. There were several people around him, maybe 5 people, 5 persons. And then there was a female that was standing several feet away from him. And I spoke with the person that was laying on the ground and then the female person that was standing up, trying to ascertain what had happened, and then keeping the persons separated that should have been kept separated.
Okay. And the location that you were dispatched to and the scene that you just described, was that located at 13903 Flairwood Drive?
Yes,
And is that located in Bear County, Texas?
yes,
And what type of location is that?
it's a residential home.
Okay. And so you make contact with multiple people on scene, is that correct?
Yes,
Can you walk the jury through the people that you made contact with?
I made contact with the person laying on the ground who was Mark Clanton. And I made contact with the person that had been driving the truck, Darren Johnson. And I made contact with a person there who said he was a witness to what had occurred.
Do you recall that individual's name?
His name is Aaron Rodriguez.
Okay. Did other officers arrive on scene?
Yes,
And who ultimately took the responsibility of writing the report that day?
Officer Gapin was a probationary officer who had been out there maybe 2 weeks. I don't recall exactly. He was with his field training officer, which was Jesus Torres Rosado. And he informed me that he wanted the probationary writer to take the main point on the investigation.
Object on the basis of hearsay.
All right, that'll be overruled.
You can continue.
And from that point on, I informed the person I had been speaking with at that time, which was Darren Johnson, to speak with that officer, Officer Gapin.
Okay. In your interaction with the defendant and Darren, well, do you see Darren Johnson in the courtroom today?
Yes, I do.
Can you please point to her and identify her by an article of clothing?
She was wearing the gray blazer.
Thank you. And so can you describe her demeanor when you spoke with her?
When I spoke with her when I arrived, she seemed a little excited. She made some comments that made made it seem to me
Yeah.
that she wanted to be non-culpable of anything that had happened.
Wait, just 1 second. So whenever attorney stands, I need you to stop talking because they're raising an objection.
Yes.
All right, defense, what is your objection?
Well, my objection is he's making a comment about what my client said, and he's using the basis of saying she seemed a little excited, but this is hearsay.
All right, with regards to hearsay, that objection will be overruled.
I guess, Judge, can the parties approach very
Yes.
briefly? Officer DeLeon, were you wearing a body worn camera on the date of the offense?
Yes.
And did that capture your interaction with the defendant?
Yes.
I'm gonna show you what's been marked as state's exhibit number 3. And I'm pulling the contents out of the envelope. Do you recognize this?
Yes.
What is it?
It's a disc from the video that I viewed earlier and initialed.
Okay, and so this is a copy of your body worn camera?
Yes.
And did you place your identifying marks on it so that you know this is the same thing that you've previously reviewed?
Yes.
And is it a fair and accurate depiction of the scene as you observed it on the date of the offense?
Yes.
And except to comply with legal rules, has it been altered in any way?
Not to my knowledge. No.
At this time, we offer state's exhibit number 3. All right, state's exhibit 3 will be admitted over defense's objection. Permission to publish, Your Honor, granted. And so we see you kind of gesturing, I'm pausing the state's exhibit. As the first officer on the scene, what are you doing when you're gesturing?
When I'm gesturing there, wanting to have the defendant step away from where the victim is at that time.
And why is that important? And
I want to keep the parties separated to keep anything from happening further. And at this point, I'm not 100% sure what's happened, so I'm still assessing. I want to get a statement from her, or at least get some information while not being near the other party.
I'm playing state's exhibit number 3 at 1 minute and 40 seconds.
Okay, were you driving?
Yes, sir.
He jumped in front of my vehicle. Oh, your driver's license? Yes, sir. You need to stand over here away from me. I'm gonna tell you one more time, okay? I don't want to repeat myself, okay?
And so when you're telling the defendant, not to give the statement at that time, is it important that all witnesses are not giving their statements in front of each other?
Yes,
And why is that?
it's important because they can hear each other and then they can take the information from each other's story.
And do you know the name of that witness that you're speaking to?
It's Aaron Rodriguez.
Under Rule 803 and 902, and I'm tendering to defense first.
No objection, Your Honor.
All right, let me see state's exhibit number 4, so I can mark it. All right, state's exhibit number 4 is admitted without objection. Granted.
Okay, Officer DeLeon, can you see that? If you have trouble, you can turn around and look on the big screen. Is that? Can you see it on that screen or you need to turn around?
I'll turn around.
Okay, are you able to observe it on there?
Yes,
Okay, can you tell me who is the patient that these records are associated with?
Mark Clayton.
And are you able to observe that?
Yes,
Can you tell me the date of birth? And can you read from State's Exhibit? Can you read that first paragraph?
Judge?
You may be seated.
Gordy, can you have Mr. Cayley jump in here real quick, and then Mr. Go off, you, Mr. Cayley can approach, please.
Okay.
I have the Benson file, by the way.
Off the record. And I'll get 2 cases and she has a warrant. Discovery order?
Yeah. Let's go to June 25th. All right, that way it gives, council gives you a little bit more time to further review all the other associated police reports as well.
Thank you, and I did file a discovery order.
Yes, I have the discovery order here and I signed it. What time works for us, Ally?
9:15.
9:15?
Yes.
All right. And then ma'am, our council asked to bond.
As Your Honor, she's posted a bond. I think under these circumstances, we'd ask that the bond be continued. She's undergoing a lot of treatment at this point in time, therapy, more than treatment. We're asking for a personal bond with obviously no drugs, no alcohol, etc.
Okay, so Ms. Cochran, if you're to test right now, what is in your system?
Absolutely nothing.
Okay, and so how long have you been in recovery, ma'am?
Well, I've only had like 2 incidents in the past, like 4 years ago, but once in a while I do use marijuana. Not all the time for my anxiety. I do not have a card. But
You do not have a card?
Huh?
You don't have a card?
No.
Okay, so while you're on bond, you can't use it.
Yes, ma'am. I understand completely.
I'm sorry, you what?
I understand completely, yes.
Okay. All right, ma'am, it sounds as though you're in a pretty dark space, in a whole lot of ways. And it sounds as though you are working your way out of that. So I'm glad to hear and see that for you.
Thank you, ma'am.
So I think that your attorney has spoken as to why we're doing this.
Yes.
And so we're going to continue your cash bond. You're not to possess or consume any alcohol or drugs unless prescribed. And we'll see you back on June 25th.
Thank you, Your
We've
Honor.
already got signed a discovery order as well. So just have a seat ma'am, and then you will receive a copy of your bond conditions, okay?
Thank you.
Thank you.
Thank you, have a good day. Okay. Who is this in custody in Wayne County Jail? Mr. Holmberg, who do you have?
Mr. Thomas, it's just a sentencing review or a jail review.
Mr. Thomas? Charles Thomas?
Yes.
All right, right, okay. All right, we're on the record in the matter of City of Wyandotte, Charles Thomas, 241503.
And good morning, Your Honor. Edward Holmberg on behalf of the defendant who's at the podium. Your Honor, today is for a sentencing review or a jail review. There is a letter, I believe dated on the 14th of May where the probation officer did a review. It looks like everything was compliant. It's a new positive test, no new charges and a zero balance.
Okay. Mr. Thomas, your name for the record, please.
Charles Thomas.
Okay, and so the court, January 29th, when the court accepted your client's plea, the court sentenced your client to 60 days jail, suspended that jail. The court held a jail review on March 26th. And, there should be two of them. Are there two cases or did the 545 case?
I thought when I originally had that there were two cases, but I think there were, yes.
So I'm not sure why we only have one up today. And can you please pull up 24545, please?
Yes. It was closed in March.
Okay, was there a jail review?
Yeah, there was a review on March 26th.
Right.
And then it said cancel jail sentence closeout.
And this one wasn't on that date either? So now I think they may have that separated.
I remember getting this date last time we were here.
Right, I'm just curious.
This one was scheduled that day and then it got moved to state. It said it was held for this one as well that day. But
Right, I don't know why I would have canceled one and.
I'm not sure. I know there were two dates. I remember two cases. I do recall that.
No, I understand that, that's why I was quite confused, I'm quite confused as to why I did that, because I typically wouldn't separate them out. Oh, maybe because there's a warrant. Out of Wisconsin?
Yeah.
Yes?
Yes, ma'am.
Okay, so what's going on with that?
I don't know, that happened 4 or 5, 6 years ago.
3 years, well, it shows dated warrant, April 28th of 22. Okay,
Yeah.
so you're aware of it, why aren't you handling it, sir?
So my last lawyer that I had for the plea and looting, and I was on probation for that, but he told me not to worry about it. I don't know.
Not to worry about it.
Yeah, that's exactly what he said.
Okay, so you should worry about it.
Yeah.
Because you could be, I mean, you could be extradited to, and it says that you're wanted. I don't think that you really want to have that you're a wanted person.
No.
It's for possession of marijuana.
Yes.
So, okay. What's the current status of marijuana in Wisconsin?
That's a good question. I think it's a more liberal state than Michigan, so I can't answer that. I would think it would be,
Okay, let me look here. Oh, well, as of March 25th, it's still illegal marijuana, in marijuana in Wisconsin. So, okay, so, sir, Everything's going well. You have continued to have negative testing, so the court's going to cancel the jail. Sir, I'm going to strongly suggest that you handle your matter in Wisconsin.
Okay.
I'm not sure what attorney told you not to worry about it. Probably not the best information we would have given. Okay?
Thank you so much.
Good luck to you, sir. Have a good day.
You too.
All right. We are on the record in the matter of the City of Wyandotte versus Ryan Joyce, 25709. And Detective, your name for the record, please.
Detective Sergeant Devin Geiger.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you may proceed on the warrant.
May 20th, 2025, approximately 3:18 in the morning, Officer Kyle Cox was patrolling the area of 4th Street and 4th Ave, traveling eastbound on 4th Avenue. He observed a red Ford F-150 bearing Michigan license plate LP02E traveling eastbound ahead of him. The license plate on the vehicle had a license plate cover obstructing view of the plate when his lights were illuminating it, creating a glare. He was also pacing the vehicle. The area is a 30-mile-per-hour zone, and he estimated that the vehicle was traveling approximately 38 miles per hour and was pulling away from him. He effected a traffic stop in the area of 19th Street and 4th Ave. And made contact with the operator of the vehicle, identified as Ryan Laverne Joyce, and there was a passenger as well. Upon speaking with the driver, he asked if there's any narcotics or anything in the vehicle. Mr. Joyce replied that there was not. He asked for a consent search to the vehicle, which at first was apprehensive, but eventually, consented. While looking into the vehicle, Officer Cox in plain view noted several torn packages, plastic baggies, indicative of narcotic use or possession. A further search of the vehicle, Officer John Berry, who arrived on scene to aid and assist, located a icebreakers candy container, which had approximately 20 individually packaged pills inside of it. The pills were familiar to Officer Cox. Reports that they were amphetamine, dextroamphetamine, the Schedule II controlled substance known as Adderall. At this point, and he also found several packages of Suboxone. At this point, Mr. Joyce was Mr. Joyce admitted to the pills being his. A MAPS report was conducted within about 2 years from May 21st, 2023 to the 25th. There's no prescription history for Mr. Joyce involving Adderall. There are several for Suboxone. Mr. Joyce does have 3 felony convictions, one 2007, 38th Circuit Court, felony license documents, plates forgery, pled guilty. 2021, 38th Circuit Court, felony child support failure to pay, pled guilty. In 2022, 6th Circuit, felony controlled substance, possession of methamphetamine, pled guilty. And that is it, Your Honor.
All right, upon examination, the court does find the offense charges committed and that there's probable cause to believe the defendant committed that offense. And counsel, good morning. Your appearance, please. Okay, so I don't see that you're muted, but I can't hear you. Nope.
I appreciate that. It's all right, don't worry about it.
All right, can you hear me now, Judge?
Yes.
All right, Attorney Corey Westmoreland appearing on behalf of Mr. Joyce.
All right, Mr. Joyce, your name for the record, please.
Ryan Laverne Joyce.
All right. And so today is the time for the arraignment and counsel.
Yes, Your Honor, at this time, we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading, enter a plea of not guilty. And you have the following rights, or you have the right to have an attorney. If you are not able to afford an attorney, you can have one appointed to represent you. And you've had an opportunity to speak to an attorney today, correct?
Yes.
The court has also signed the petition for an appointed attorney form for felony matters. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, ma'am.
All right, the court's going to enter a plea of not guilty and we have scheduled this matter for probable cause conference on May 29th.
10:15.
At 10:15 a.m. Counsel asked to bond.
Yes, Your Honor, I would like you to know that Mr. Joyce currently is residing in Allen Park. He is gainfully employed full-time at U.S. Foods Distribution. He's not currently on probation or parole. He has no other pending matters at this time. He has never failed to appear in court for any reason, and he does understand the importance and assured me that he would be appearing at all future court dates.
Okay. And sir, if you were to test right now, what's in your system?
What's in my system? Suboxone.
All right, do you have a valid prescription for Suboxone?
Yes.
Have you ever failed to appear in court for any reason, sir?
No, ma'am.
Are you currently on probation or parole?
No, I've completed every bit of everything I've had. With no failed drug test, no nothing.
And you're not out on bond in any other jurisdictions?
No, ma'am.
Okay. All right, detective asked to bond.
A bond to assure his presence in court. He didn't resist, obstruct, or assault our officers, who appeared to be somewhat cooperative. Just we asked no drugs or alcohol unless prescribed, and on the $200 bond.
All right. The court will note that based upon the nature of the charges and reviewing the criminal history, which would support the third offense felony matter, the court does have concerns for the safety of the public. And the court wants to ensure that Mr. Joyce will be returning to court. The court's going to order a $2,500 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed. And we'll see you back on May 29th. Thank you.
Thank you, Judge.
We're on the record in the matter of the city of Wyandotte versus Angela DiMaggio. Oh, good. Oh, Mr. DiMaggio, it's been a little bit. 2573.
Attorney Corey Westmoreland appearing on behalf of Ms. DiMaggio. Ms. DiMaggio, would you please state your full name for the record?
Angela DiMaggio.
Okay. I think, doesn't she have some words with us? I think she's has some words with us. Counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment. And as to the pre-trial, we'll schedule that for June 4th.
10:45.
At 10:45 a.m. And counsel as to bond.
Yes, Your Honor, I would like to know that Ms. DiMaggio is currently residing in River Rouge. She is gainfully employed at American Care doing home health care. She's not currently on probation or parole, and after speaking with her at length this morning, she did assure me she would be appearing at all future court dates. I would just ask that all that be taken into account.
All right, I think that we have some outstanding warrants for Ms. DiMaggio. What's that?
I said I don't have any warrants, ma'am.
You don't?
Oh, no, everything is cleared up with us.
Okay. All right, well, ma'am, if you're in test right now, what's in your system?
What, ma'am? Alcohol.
What's that?
Alcohol.
Alcohol, okay. And where are you working? Home health care?
Yes, ma'am.
And how long have you been doing that?
About 10 years.
Are you out on bond in any other jurisdiction, ma'am?
No, ma'am.
Did you put her matters, did she have any?
So she doesn't have any warrant, she just has.
Okay. So ma'am, how, it appears though you don't have any warrants with us, but you have outstanding balances with the court here. All right, do you have anything else in your system other than alcohol?
What's that?
You don't have any, you wouldn't have anything else in your system other than alcohol?
No, ma'am, no, ma'am.
Right. Based upon your criminal history, review of your criminal history and the concerns of the safety of the public, the court's going to order a $2,500 10% bond. The court's also taking into consideration that you do owe balances to this court that you have yet to take care of. So we will see you back on June 4th at 10:45 a.m.
Yes, ma'am, thank you, have a good day.
Thank you.
You're on the record in the matter of the state of Michigan versus Davin Henry 25694. Okay, and counsel, your appearance for the record, please.
Attorney Corey Westmoreland appearing on behalf of Ms. Handling.
All right, this matter was sworn to yesterday. The court signed the warrant. And ma'am, your name for the record, please.
I'm sorry?
Your name for the record, please.
Evan Hanley.
All right, and counsel has the arraignment.
Yes, Your Honor, at this time, we are prepared to waive a formal reading. My client stands mute.
The court's going to waive the formal reading. You have the right to have an attorney. If you cannot afford one, the court, you can have one that's appointed to represent you. You have, and in fact, you've had an opportunity to speak to an attorney today, correct? The court has also signed a petition for appointed attorney as well for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights? Do you understand those rights, ma'am?
Yes.
The court's going to enter a plea of not guilty. We have scheduled this matter for a probable cause conference May 29th.
10:15.
At 10:15 a.m. As to bond, and then I'll give Sergeant an opportunity to respond.
Yes, Your Honor. Ms. Hanley currently is residing locally in Wyandotte. She does work locally for the Downriver Appliance Repair. She has no prior criminal history whatsoever. She's not on probation or parole, has no pending matters, and after speaking with her at length, she did assure me she would be appearing at all future court dates and understands the importance of doing so. I would just ask that all that be taken into account when assessing a bond.
So, ma'am, if you were to test today, what's in your system?
I'm sorry?
If you tested today.
If you were to test today, what is in your system?
Nothing. Just my regular prescriptions that I have from my doctor.
Okay, and what are those?
I take Adipex, Topamax, I'm sorry, I have a head injury, so it's hard for me to remember everything. But Symbicort, just stuff like that. That's it. No drugs, no alcohol use, none of that.
Are you currently out on bond in any other jurisdiction?
No, ma'am. No judge. Sorry.
Have you ever failed to appear in court for any reason?
No.
Are you on probation or parole anywhere?
No.
Sergeant, would you like to address bond?
I would suggest 10,000, 10%.
It appears as though there's some pretty serious injuries that are alleged as a result of this. And in addition, that there seems to be such an impact that there's damage to a building as well. And the court is tasked with protecting the community as well as making sure that Ms. Hanley is going to appear. But the court's main priority at this point, based upon the allegations and the nature of the injuries to the individuals, the court does find that a $10,000, 10% bond is appropriate. In the event bond is posted, you're not to possess or consume any alcohol or drugs unless prescribed. You're not to operate a motor vehicle. I understand you have that license, but right now, that right is being temporarily restricted and removed from your ability because the court wants to ensure that the public is safe. The court's going to also order an alcohol tether to the Wayne County Jail. And then we will see you back on May 29th.
Thank you, Judge.
Thank you. Emily Needham. 25707.
Attorney Corey Westmoreland appearing on behalf of Ms. Needman.
Okay, ma'am, your name for the record, please. Your name for the record, please.
Emily Page again.
Okay. And counsel asks you to remain.
Yes, Your Honor. I did have an opportunity to speak with my client. She had no further questions for me, so at this time we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. We will schedule this matter for pretrial on June 4th.
10:45.
At 10:45 a.m. and as to bond counsel.
Yes, Your Honor. My client's currently residing in Livonia. She is a single mother to an 8-year-old. She is currently on probation in Rockwood. She did assure me she would be appearing at all future court dates, and she does understand the importance of doing so and assured me she would be here on time every time. I would just ask that all that be taken into account when assessing a bond.
Ma'am, what are you on probation for?
Same thing.
It's a charge called same thing.
Possession of narcotics.
Ma'am, if you're to test right now, what's in your system?
Cocaine and heroin.
How long have you been on probation, ma'am?
For a long time. I'm actually, I have to finish up a couple things and then I'm done. I don't know how to explain it. I'm supposed to be off in the 24th, or I'm supposed to be off in October.
This October?
Yeah.
Well, ma'am, your criminal history is littered with possession charges, felony and misdemeanors, and in multiple jurisdictions. The court has some serious concerns for the safety of the public as well as your own safety. Therefore, the court's going to, the fact that you're on probation for a charge that you're now currently in custody for, the court's going to order a $7,500 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed to be subjected to random testing. Ma'am, where do you work?
I switch trucks.
What's that?
I work for Superior Switching.
And who has your child right now, ma'am?
My mom.
Okay, well, I want to give her a call, let her know that you're going to be in custody unless you post that bond. Thank you. Have a good day.
Thank you, Judge.
How much do I got?
Your record in the matter of the city of Wyandotte for Stephen Wilcox. 25633. Mr. Wilcox?
Yes, ma'am.
Okay. Good morning.
Good morning.
Okay, and your name, sir?
For the record, Steve Wilcox, attorney in my own behalf.
Okay, and are you a licensed attorney, sir?
I am not.
Okay, I just wanted to confirm, because I see an appearance on here, and then, that you're representing yourself, and there's not a P number next to it, I just wanted to see if you were, you can come to the podium, sir. All right, and so, sir, you are waiving your right to an attorney, correct?
Correct.
Okay, can you sign the waiver of attorney? Can you give me the waiver of attorney form, please? Okay, and sir, you understand that you are here on criminal charges today, correct?
Yes, Judge.
And you also understand that you have the right to have an attorney represent you at all critical stages of the criminal process.
Yes.
And you also understand that if you cannot afford your own attorney, you can have one that's appointed to represent you.
Yes.
And that there are attorneys here to represent you.
Yes.
And knowing all that, you want to waive your right to an attorney, correct?
Yes, Judge.
Okay. And you had an opportunity to speak to the prosecuting attorney, correct?
I have spoken with Mr. Cayley this morning.
Okay. And what do you understand as the resolution?
The charges would be no prost.
Okay. Mr. Cayley? Mr. Cayley? Sherry, I'm sorry, before you go that way, can you ask Mr. Cayley? Please. Mr. Kaylee? Your appearance, please.
Roger Kelly on behalf of people, City of Wyandotte, Your Honor.
Okay, thank you. Yes, Mr. Wilcox, the people are moving to know this process?
Yes, Your Honor. The co-defendant's his brother. The drugs were found on him and in his backpack.
All right, the court will grant the people's motion to know the class. And Mr. Wilcox, you did post a bond. Please stop at the window, confirm your correct address. The court processes bond refunds monthly, so that will be refunded to you less than 10% the next time that we are processing those refunds.
That's
Okay?
fine, Judge.
All right, good luck to you, sir.
Thank you.
Thank you. We are on the record in the matter of the City of Wyandotte versus Amanda Trent, 25651 A and B. Mr. Wilcox, thanks for dressing appropriately for court. Okay. All right, Russell.
Yes, good morning, Honor Neil LeBoy here on behalf of Mr. Trent. Just state your name for the record, please.
Amanda Trent.
Thank you.
I thank you. Today is the date scheduled for the pretrial of this matter. And counsel?
Yes, Your Honor, my client waives formal reading, stands mute to the charge.
All right, the court
Charges.
waives the formal reading, enter a plea of not guilty for purpose of the arraignment and asks for the pretrial.
As the pretrial had an opportunity to review this with my client and as well as with the city attorney. This time, she is prepared to offer a guilty plea to the amended charge of operating while visibly impaired. The original offenses of operating while intoxicated and also having open intoxicant in the vehicle would be dismissed. Is that correct, Miss?
Yes.
Thank you.
All right, please raise your right hand. You solemnly swear from the testimony you're about to give this matter the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone over your advice and rights with your attorney, correct?
Correct.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
Yes, and you understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency?
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please pardon your client.
Yes, I will. Ms. Trent, you recall being in the city of Wyandotte on about the 12th of May this year?
Yes.
And at the time you were operating a motor vehicle in the area of 4th Street, is that correct?
Yes.
And prior to operating that vehicle, had you consumed some alcohol?
Yes.
How much and what was it?
I don't know how much those whole beers.
A couple 24-ounce beers?
Yeah.
Is that right?
Yeah.
And after consuming that, you were pulled over by a police officer who alleged that you were driving somewhat erratically, changing lanes and so forth. Is that true? Do you dispute that?
Yes.
And normally, you don't normally drive in that fashion. Would you attribute your consumption of alcohol? Was that a contributing factor to that erratic driving?
Yes.
And after being taken into the station, you cooperated and you performed a test known as a breathalyzer. And that breathalyzer result is indicated in the report as 0.114 and times 2. That's 0.114 and again 0.114. Do you dispute those numbers?
Okay.
I'm
You're
sorry?
right.
I didn't hear what you said.
No.
Okay.
Your Honor, I'm satisfied with that.
The court is also satisfied that there is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss your original charge for the plea agreement, and the court will, you will get your sentencing date from probation. You will also receive your needs assessment information. You will also receive your pre-sentence interview information as well as your pre-sentencing date and your sentencing date. Okay, if you were to test right now, ma'am, what's in your system?
Nothing.
All right, bond conditions are continued. Please have a seat over probation. Somebody will be with you shortly.
You know where you're going? I'm gonna go around, have the windows and up the hall.
Okay, like we're not first.
Good luck.
Thank you.
And we're on the record in the matter of the city of Wynot versus Jared Halo 25152.
Ready, Your Honor. Your Honor, Neil Boyer, on behalf of Jared Halo, please step up and state your name. Jared Halo, thank you.
All right, thank you, and good morning. Today's date scheduled for sentencing in this matter, and the counsel, do you have an opportunity
Yes.
to review the report and recommendation with your client?
Yes, we have. It is accurate without need of any adjustments. With respect to the recommendation, I think there was a recommendation, non-binding, recommendation only by the probation, excuse me, by the prosecutor of 6 months. I think 6 months would be appropriate in this case. If you're looking at the facts of the case, Mr. Halo was out with his friend. They had, they got a little disorderly. They're still friends today. Is that correct? That's correct. So it wasn't a major deal. Someone came upon them. The police came upon them, and as I said, they were, basically it was just between two friends that got out of hand. They're not supposed to do that. He realizes that that's why in this circumstance the 771 is appropriate. This shouldn't stay on his record. He's embarrassed about it, but if the court will consider whether 6 months would be adequate.
Well, I think your brother-in-law was just here yesterday.
Yes.
I think. Can you put Gasiewski, please? Because what I'm going to do is I'm going to make sure that their sentences are the same. I don't recall I did Mr. Gasiewski.
I'm not responsible for the inadequacy of Mr. Gasiewski's attorney.
I think it was either 6 or 9 months, I don't recall.
Is the first name Christopher?
Yes.
Does 12 months probation.
Oh.
I retract the request, Your Honor.
Okay, I don't recall why I did that. That was yesterday.
Well, it shows the probation was the 3rd. They were here the 14th.
Oh, it was last week? Huh, oh, like yesterday. Okay, there may have been some other factors with his criminal history or what have you, so.
Mr. Gasiewski's is my client's brother-in-law?
Correct,
So he
yes.
knows very well, he has a criminal history, whereas Mr. Halo does not.
Correct, so I believe that was why, and I believe that Mr. Gasiewski has some additional alcohol-related offenses. And he had
That makes sense.
much higher level than your client did, even though your client's level is pretty high. Mr. Gasiewski did have a higher level. Anything else, counsel, before the court proceeds?
No, Your Honor.
All right. All right, so Mr. Halo, if you were to test right now, what's in your system?
Possibly marijuana, but it has been weeks since any consumption.
A week?
No, it's been weeks since any consumption.
Weeks?
Yeah.
Okay. All right. Sir, I'm presuming that you and your brother-in-law hopefully will not be drinking together at any point, at least within the the term that you're all on probation for. But hopefully, whenever you guys are running your mouths at each other and throwing digs at each other, that, you figure it out and realize that, fighting isn't the way to do that, especially intoxicated out in the public, because perhaps you're remembering it the next day. But the court's going to state that the court does find after hearing from counsel, hearing from Mr. Halo, reviewing the report, the recommendation that that there is reasonable grounds to depart from MCL 76925. The court also finds the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter and the circumstances surrounding Mr. Halo in light of the legislative guidelines. The court's going to order 9 months probation. You're eligible for early discharge, so I'll go over that in just a short bit. You're also eligible under 771.1. The court's going to order you not to violate any criminal law or any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer its office or probation officer may require, in person, writing, or virtually. You notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition so the court can monitor your progress in maintaining abstinence and sobriety. And then the court's going to order you to participate in the chemical awareness program. The rehabilitative goal for that condition is so that you can further educate yourself regarding drug and alcohol use so you can make better informed decisions in the future, hopefully preventing this matter from happening again. Okay, do you have any questions regarding those conditions? Okay. And then as to the fines and costs, the court's going to order a $200 fine, $100 screening assessment fee, supervision oversight fee of $450. That's $50 a month at 9 months. And since you're eligible for early discharge, up to half of that may not be due. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, chemical awareness program $75. So $1,250. Keeping in mind that $225 may be waived. Okay, and so do you have any of that to pay today, sir?
I probably paid 300 today.
Okay, you also posted a $250 bond, so that would be $550 total today. And then I'm going to have you set up payment plan through probation for the balance, okay?
Thank you, ma'am.
All right, and as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've been in good faith efforts for making full payment. Okay? All right, good luck to you, sir. Please have a seat on your probation. Somebody will be with you shortly. Okay. Oh, Mr. Wilcox, did you have something else? Mr. Wilcox have something else?
No, I was waiting on my brother to get called. I don't know what Mr. Goldpaw is doing.
Oh, okay, all right.
I see that he wasn't on Zoom anymore, so thank you, Judge.
Okay, thank you. Was there something else on the county jail?
Yeah.
Okay. All right, so we are on the record in the matter of the city of Wyandotte versus Zachary Mullins.
Where?
2567A.
Somebody